Logical evening, everyone. Fantastic it feels to be before you, and the countdown begins. आज के बाद we have 17 more days to go for the D-Day. The days are getting numbers and we're getting all set to ensure that we nail it hard on the D-Day. So, welcome to Gladiator Series Mock 2267 Legal Reasoning Practice Series. So, I think if I talk about today's test, before I go into that, I would just want to share this message. No, don't stop till you haven't reached. Don't sleep when you're tired. Sleep when you are done. Such kind of feeling is required. All the sweat that you are putting in, all the efforts that you are having right now, will give you appropriate field, appropriate yield, and appropriate results in the times to come. Let's get set to hone our platitude. I've always been saying, worry less, work more. Worrying is like a rocking chair. It gives you something to do, but it doesn't take you anywhere. That's true. Push yourself. And yes. Asking me how was this test? Before starting with the legal reasoning, let me tell that this test, it was moderate. Going further, giving you an overview about how this test was like, it had 7 passages. Because on the day of CLAT, you might have 7 or 8 passages. That is what we assume. And at Vidhigya, what we call as ISS, while doing that intersectional sequencing part, it becomes difficult for us at times to just understand and figure out which to take first and which one to take later. So we had got 7 passages and 40 questions. The first passage was about assault, battery, and false imprisonment. The questions were decent and competitive. Then we had state emergency as it is provided under Article 356 of the Constitution. Then we had quasi-contract, then agreement and restraint of trade and profession, then the concept of marital rape, then character evidence, and this was interesting. It was similar to CLAT 2021 question of compassionate appointment, where you find one idea being stretched long and the questions on that. I mean, language heavy passage. And finally, we had National Human Rights Commission on fake encounters. With that point, Cyril, let me tell you, when I talk about a legal reasoning section of 2266 practice series, in my opinion, somebody getting 32.5 or more today out of 40 has got a decent score. It's the fantastic score. It's the best in line to crack the exam. Somebody getting 29 or more is a very good performance. 26.5 out of 40 is a decent performance. 23.5 out of 40 average performance, and someone who's scoring 20, say come. Anything that is less than 20 on board, it's a lot to work. So I am sure you had a good time, and with this we go ahead and offset. The skimming method helps. Then these are the things that you should look for. I've told many times, so for the sake of brevity, not repeating. Focused mind. So sequencing becomes very important while you are taking the overall mocks. And here we go with the passage. Now, when I talk about the first passage, it comes from the area of law of torts. So if this topic was pre-known to you, if you are very well aware about this topic, I think it would have been an easy game. It would have been an easy nut to crack. Therefore, when I talk about this first one first, the passage is all about assault and battery. The word corporeal means bodily. So here because since you have already solved these passages and you know this topic very well is my assumption, because it's one of the basic topics of law of torts. So that's what my assumption is. Now let's understand what was the author's story here. Author in the first paragraph is trying to say that assault is nothing but reasonable apprehension of battery. That is a apprehension, and that too a reasonable apprehension that some force is going to be used against a person. To the contrary, the meaning of battery is transgressing into body of someone. The meaning of term battery is intentional and direct application of physical force upon a person. Then there's some differences being explained. Later, when we see the second part of it, then it is about false imprisonment, total restraint of liberty of a person, and then these are two criteria provided. If this passage is clear to you, if you tell me why, if you write why, I'll be more than happy proceeding further with the questions so that we can utilize this time better. Your time is very valuable these days, just 17 days to go, so we'll go it that way. If you're clear with the passage, we quickly see the questions and we quickly see where things could have gone wrong. Wonderful. So let's go into the questions. Wonderful, wonderful. Great. The first question on your screen is here. A teacher is suffering from arthritis. One of the students saw a scorpion. He immediately rushed to attack the scorpion and in the process moved a chair. As a consequence, the teacher fell down and broke his back. A suit was filed against the student for battery. Decide. Now our passage says very clearly without a lawful justification. The meaning of battery is use of physical force without a lawful justification, and there was a scorpion, and scorpion being there, it was a lawful justification. So then, I mean, everyone, Asad, Sundaram, Parul, Aviral, Jayesh, Mahima, Alok, everybody is right, though Alok did not write option. Jayesh and Mitanshu, A Agra is the answer without an iota of doubt. The reasoning is clear. I'll just try to point out what was the reasoning and we'll go ahead. Going to question number 2. In the facts of the last question, if instead of student, a colleague of that teacher would have jovially pulled the chair from under him in the faculty room. Now in this case, jovially pulled, and there it is written intentional force. So please understand what's the meaning of word intentional. Intentional force here means knowingly. And when I say knowingly, you at time lose this question. You believe that intention is malified. Intention is not equal to malified in this case. Intention means doing something knowingly. So in this case, that colleague of the teacher knowingly had pulled the chair, and finally, as a practical joke or whatever, the teacher has landed on floor. That means there have been a corporeal hurt. Here is given a word, corporeal hurt, physical force. So with that point settled, we very well understand. Many students, Abhishek Joshi saying C, Tanish saying C, let's see. He is not liable as it was not intentional application of physical force upon the person. That's the answer in one sense. He is not liable since there has been no element of bodily hurt. Seemingly many students are marking this as well. Let's look at the question clearly and see. Colleague is liable as his act amounts to battery is the clear-cut answer. You look at this question. A landed on the floor as they were good friends without any ill will, practical joke upon the said teacher. Consequently, the teacher landed on floor but was unfortunately unhurt. Now, please understand in this case, anyone who pulled the chair has caused battery and the colleague is liable for the tort of battery. Answer is C, Calcutta. A lot of students marking A or otherwise. If anybody has any doubt can ask, otherwise I'll move further. Anybody having any doubt? Otherwise quickly we'll go through. It was an intentional application of force. Clear? Going to question number 3. Good going. Vidhan was in his car and he was approached by the police officer. Aviral Billore, नहीं हुई रीजनिंग क्लियर? टीचर, टीचर के फ्रेंड, ये टीचर बैठने वाले हैं, इनकी चेयर पुल कर दी और ये जो टीचर हैं ये फेल डाउन। फेल डाउन का मतलब क्या होता है? गिर जाना। गिर जाने का मतलब क्या होता है? बॉडीली। टॉट ऑफ बैटरी का मतलब नहीं है कि किसी को बहुत ज्यादा चोट लगे। इट्स मियर इंटरफियरेंस विद द बॉडी ऑफ अनदर पर्सन यूजिंग फोर्स अपॉन अ बॉडी ऑफ अ पर्सन, सो इट्स लाइक बॉडीली हर्ट। नाउ द क्वेश्चन इज, द मोमेंट अ पर्सन सी ही हैज पुल्ड द चेयर और वो नीचे नहीं गिरता तो होता असॉल्ट। किसी ने चेयर खिसकाई, वो देख लेता, नहीं गिरता तो इट वाज असॉल्ट। बट द मोमेंट अ पर्सन फेल्स डाउन it becomes battery. Answer is colleague is liable. C. Calcutta. Aviral Billore, did you get the reasoning right? Coming to question number 3. Vidhan is approached by a police officer. He reversed the car and rolled it on the foot of a police officer. यहां तक intention नहीं दिखाता facts में. But going ahead, the officer forcefully told him to move car off his foot, at which point Vidhan swore at him and refused to move vehicle and turned the engine off. Now in this case, what is he doing? He is causing battery. With this fact, the answer is clear. Alright, so talking about question number 3, the answer is C. Calcutta. Everyone marking C, there's no iota of doubt. Let's go ahead with question number 4. There are two people, Carolina and Priyanka. They are finalists for Miss India crown. They are biggest rivals. On the day of grand finale, understand, she is locked inside her room. Please understand this well. Priyanka has locked Carolina. Now, storeroom is having another exit. Had कैरोलिना नोन दैट देयर इज एन एग्जिट, कैरोलिना को पता होता कि एक और एग्जिट है और वो निकल सकती थी, तो ये टोटल रेस्ट्रेन नहीं होता, तो ये फॉल्स इंप्रिजनमेंट नहीं होता। लेकिन कबर्ड के पीछे एक एग्जिट है ऐसा कैरोलिना को नहीं पता था। इस कारण क्या हुआ? शी कुड नॉट रीच एंड दिस लेडी हैज वन द क्राउन। लेटर दिस लेडी, after 6 hours, and we have read that false imprisonment has nothing to do with the duration of time. Is Priyanka guilty for false imprisonment? Answer is definitely yes. So the answer to this question is, many of you saying A and C. Let's see. No, because there was not a total. This is wrong. Malified intention, nothing to do. Answer to our question is C, Calcutta. C. Total restraint. Are you clear with the reasoning, people marking A? If you're clear, then we'll go quickly ahead. Going to question number 5. Identify assault and battery in the following two cases. 1. Vidhan's parents did not let him out of house as the temperature was really high and warned him not to go out as Vidhan sued his parents. Lawful justification, false imprisonment नहीं होगा. Second, ना false imprisonment होगा, ना battery होगी, ना assault होगा. Vidhan, a rock star in concert, one of the fans threw a tailor-made bouquet of rose flower towards him. Tailor-made, उसी के लिए बनाया हुआ था. Keeping maximum thorns in it. One of the thorns of the bouquet hurt Vidhan. He sued his fan. What is the case like? The case is battery. 1 is neither battery nor assault. 2 is battery. In my opinion, D. Delhi seems the best answer. People marking Delhi. Good going. Let's go to the next one. Vidhan saw a YouTube video and called Dhruv Lathi, telling him not to copy his jokes or else Vidhan will beat Dhruv blue using stick and stones. Dhruv is living. Now Dhruv and Vidhan. Now Vidhan is of course threatening him. क्या threaten है? Stick and stone. But where is Vidhan? Dhruv is in Indore. Vidhan is in Delhi. That is inference from the question. And now how can he use stick and stone to hit this person? And in our question, in the definition of assault, ability to cause harm is in the very first or second line. Can he ever cause? Answer is probably no. Answer is B, Bombay, without an iota of doubt. So you're done with this. Let's go to the next one. Passage 2. Passage 2 is about President's Rule. Now, President's Rule, if we quickly look, it's part 18 of the Constitution and the title is Emergency. Article 352 talks about national emergency. Article 356 talks about state emergency. And Article 360 talks about financial emergency. Now, President Rule, suspension of इस पे, though it is not mentioned in the passage, but कई बार passage में SR बम्बई का केस आता है. We must know about this. Anyways, President rules refer to suspension of state government. Then Article 356 says that President is having power and that can be done using advice of Council of Minister headed by Prime Minister, and the conditions are 1, 2, 3, 4, 5. इलेक्शन पोस्टपोन हो गए हो कोरोना के कारण, मेजॉरिटी खत्म हो गई हो, वोट ऑफ नो कॉन्फिडेंस मोशन आ गया होगा. देवजन होना ही ऐसा चाहिए ना. देयर शुड बी मेनी क्राइटेरिया गिवन. टोटल ब्रेकडाउन, कोलेशन सरकार, खिचड़ी सरकार गिर गई हो. हमारे देश में, आफ्टर 1993 till 2000 there have been a lot of coalition governments in the center and they all collapsed. अटल बिहारी वाजपेयी जी ने एक बुक लिखी है, The Politics of Coalition. Anyways, गठबंधन की राजनीति. The state government is unable to elect the leader as chief minister and within time prescribed by the government. और ये 5. So, keeping it short. इसमें कोई criteria समझ में नहीं आ रहा तो I can explain, otherwise we go ahead. Then they say proclamation under 356 is for 6 months and it can be extended for 3 years. President rule can be revoked by president and does not require parliament's approval. Then saying that 44th amendment has changed the scenario. First thing required is election commission, saying that election cannot be conducted, and second, that there's a national emergency in India or any part of it. Then they have already explained about this, and this is all what the passage was all about. I think we're good to go with the questions. Chale, fatafat. Chalo. Let's see questions. Union government has passed law. A list of citizens of the country has prepared. Vagera vagera. State possesses enforced mandate laws. The scheme of the constitution. There are 2 states. They have passed resolution that they'll not enforce this new law. So what is this? Now if you read this part, that state cannot be carried out in accordance with the constitution. इस वाले criteria में state cannot be run as per the provisions of the constitution. So when we talk about question 7, Abhay, Parul, Sundaram, Aviral, Ayush, Asad, Mahima, Diya, Anurag. Diya saying B, rest saying A. It's not about whims and fancies, rather it's about failure of state to abide constitution. A, Agra is the answer. Going next to the question number 8. Parvovirus is spreading like wildfire. 2 lakh people are sick. State administration is unable to deal. Election commission, काम की बात है, postponed election due to such epidemic. To stop the spread, army is needed. Governor proposes that state should be placed under president rule until elections are held. Suggest. Answer is very simple, that in this case is president's rule can be imposed because it's a question where we find an exception called epidemic. Criteria था ना, epidemic हो तो कर सकते हैं. Without, it's a no-brainer. Question number 8, answer is Bombay. Going quickly to question number 9. In the above question, assume that these questions are good. In the last question, assume that The state of XYZ has placed under president rule. Moreover, the epidemic has reached all India and national emergency have been imposed. The president rule under XYZ has been extended for 6 months. Can extension be challenged by Chief Minister of XYZ as constitutional? Will he win? Now, when I talk about question number 9, he'll not win because president rule can be extended when the question is about national emergency. Answer is B, Bombay. Going question number 10. Which of the following cannot be inferred from the above passage? President's rule leads to the direct control of state in the hands of central government. Yes. Next, president's rule can be extended from initial time period where for compelling reasons. Yes. Once the president rule is revoked, governor of state is relieved from it. This cannot be inferred. Nowhere provided. Answer C, Calcutta. Correct. Going next. Question number 11. In which of the following cases such kind of questions, such variety of questions, such way of writing of question was asked in CLAT? President rule can be invoked. In the state of XYZ, no party has reached majority. कर सकते हैं. Post poll alliances have not been possible. कर सकते हैं in this emergency. War हो गया. President rule has been imposed. In this case, answer is C, Calcutta, both 1 and 2. Now we come to something called quasi-contract. Before I go into the word quasi-contract, these are what? Quasi-contract is basically no contract. They are contract-like obligations being imposed on the parties in the light of equity, in the light of fairness, so as to avoid unjust enrichment. So, keeping it simple, quasi-contract वो situations हैं जहां पे पहले से कोई कॉन्ट्रैक्ट नहीं होता पर वो सर्कमस्टेंसेस ऐसे हैं जहां पे कॉन्ट्रैक्ट जैसे ऑब्लिगेशंस मान लिए जाते हैं जिससे कि एक आदमी जिसको गलत तरीके से नुकसान हो रहा था उसके नुकसान की उसे भरपाई की जा सके. This topic is a well read, understood topic in the classroom of CLAT and contract. If the students are clear with the concept, I think we'll go ahead and we'll quickly see the meaning and understanding. No man must grow rich out of another person's loss. Unjust enrichment, unfair enrichment, जहां पे जो फायदा आपको नहीं पहुंचना था अगर आपको मिल जाता है तो वैसा फायदा आपको वापस पहुंचाना है. That is what quasi contract in crux would mean. Harsh Gaur says yes, he's able to understand. I think all have the similar opinion. Just let's break into the questions. A ordered pizza. Man lives on 8th floor, while his friend B lives on 1st floor. The delivery person arrived, stopped him, asked him to give pizza and told that letter will deliver pizza to A as he happens to be the brother living in the same house. इसने गलत जानकारी दे दी. Dev Jain sir didn't understand the passage. Dev Jain, this topic is well discussed. And quasi-contract is a topic, if you have not brushed it up because it's a topic of 20-25 minutes. There are 5-7 circumstances. इस पैसेज की लाइट में पढ़ोगे तो थोड़ा ही पढ़ोगे और ये पैसेज बहुत अच्छे से पढ़ लेना. Quasi-contract, there is a likelihood that we might find a passage coming in CLAT as well. जो क्रक्स में समझाना था वो मैंने समझा दिया. Just do with that, and still if you're not able to get, just come back to me if I can help you. Now, when I talk about the case, here A has given a misinformation, and relying on this misinformation, pizza boy has given pizza to him. B is not the brother, he lived in the adjacent flat. Okay. Now, in this particular case, is there a quasi-contract between A and B? Of course. The answer to this question is yes, because it is in the light of equity, unjust एनरिचमेंट। ठीक है, ऑलराइट, गोइंग विथ क्वेश्चन नंबर 12 डन, लेट्स गो टू क्वेश्चन 13 quickly. If I can have your inputs, question number 13. If I can quickly have your inputs, simple question. It's a no-brainer. 13, needless to explain. B is the answer, is it? Diya Lunawat, how can B be the answer? Understand. What did he do? In this particular case, he's forgotten his mobile phone. Now he wants his mobile phone to be returned. Can he compel? Answer is yes. So anyone marking B is a horrendous answer. Answer is of course A, Agra. A is the answer, only possible option. Which of the following can be inferred from the above passage? Quasi-contract can be given effect only by court. Does not require consent of parties. Yes, these two things can be inferred. Quasi-contract makes good for the loss. Yes, so answer is D, Delhi. Question number 14 is simple. Let's go to question number 15. Vidhan has ordered a dress online for his wife. The delivery boy has mistakenly delivered the dress to the lady in their neighborhood. The neighbor has used the dress, thinking that it was ordered by her brother. Is there an obligation on the neighbor to return the dress to Vidhan? Answer is yes. Why? Because that would be fair in the light of fairness. And that is what is quasi-contract. Answer is yes. It is their responsibility. How come? Because it's a quasi-contract. This is the right reason. यहाँ तक दोनों सही थे. This is the reason in the light of passage. Straight away going after 15 to next question 16. Vidhan promised Vidit to deliver goods but mistakenly deliver goods in Vidhi's house whose neighbor Vidhi consumes the good. Later refuse to pay them. Quasi contract होगा, हाँ होगा, पक्का होगा. Vidhan and Vidhi jointly owe some money from Vidhi. Later pays Vidhi, but Vidit unaware also pays Vidit the some amount. So in question number 16, we get to say in both the cases, fairness के हिसाब से quasi contract apply हो जाएगा. C is the answer. Abhishek Joshi, you're wrong. Aditi Khandelwal is wrong. Sundaram is wrong. विदित ने भी पैसे भेज दिए. एक बार ए और बी से जॉइंटली 1000 रुपए चाहिए थे. ए ने पूरे 1000 पे कर दिए. अब बी ने जाके भी मान लो आधा पैसा 500 रुपए और दे दिया, तो ये 500 रुपए तो ए के पास गलत गया ना, इसे रिटर्न करने चाहिए. क्वाज़ी कॉन्ट्रैक्ट होगा, हाँ ऑफ कोर्स होगा. किसके? बी और इसके पर्सन के बीच में. दिस इज नो ब्रेनर. 16 वाला गलत नहीं होना चाहिए. इट्स सी कैलकाटा. Passage 4 is an agreement and restraint of trade and profession. Now, it's about section 27 of the Indian Contract Act that no person shall be restrained in carrying on trade and profession of his choice by the virtue of a contractual arrangement. Now, after this, the passage provides two exceptions. One is sale of goodwill and B is Partnership Act. Now, they say that no person shall be restrained to carry on trade and profession of his choice, but there are two exceptions possible. One is the goodwill, and when we talk about goodwill, they say such limits as it appears reasonable to the court and the nature of business. Second, in partnership, they say for a specified period or specified local limits. So these are the restrictions available. The agreement should specify the local limits of the restraint and the impose should be reasonable. Understanding these points, let's straight away go to the questions. Vidhan and Vidit came to agreement of sales of good, where Vidit was supposed to supply goods to Vidhan in the market. Once the term was mentioned that during the pendency of the agreement, Vidit cannot work anywhere else or in any other business. Vidhan says that such agreement is violative of Section 27 of Indian Contract Act. Will he succeed? Now, Section 27 allow freedom of trade and profession. In this case, will he succeed? Answer is yes. To people, those who are marking A, you were tricked. It's wrong. C is correct. It was a twister which you failed to see. Yes, he will succeed as 27 does not allow. No, as 27 allows. Answer is Calcutta. People marking A, Ayushi and Aditi, A square beta have gone wrong. Jayesh, ये तो reasoning के बाहर है जो तुमने mark कर दिया. So I hope you got this right. Let's go to question number 18 then. Vidhan is an overall establishment known in Indore by name for good quality products. Vidhan wanted to relax, so he sold this part of business. This part of business as a shop in one area of Indore to Vidit. They signed the agreement of sale of goodwill, pehla wala exception, which prohibited Vidhan from running or opening any other shop in Indore area. Is this term of contract allowed by law? Answer is yes, क्योंकि ये exception थी. Now looking yes, this is wrong reasoning. Yes तक ठीक था, reasoning गलत है. D Delhi is the answer. Diya saying C Calcutta is wrong. Sakshi has already retracted the message. Parul going wrong. So that's how it is. It's going to be D Delhi only. If you have any doubt anytime with reference to reasoning, just ask me. I'll be more than happy replying you. Vidhan has joined a new firm. ये हो गया exception 2. Now exception 2 was about partnership. In the agreement, it was mentioned that Vidhan cannot be a part of some other firm as long he is the partner of XYZ. Vidhan was found to be a part of some other business. They terminated, saying that he violated the terms of agreement. Vidhan sued the firm for making deed violative of ICA. Is it violative? Answer is no. Why? Because it's an exception. So, Anurag, Harsh, Asad, Priyashi, Sundaram, Parul, Aviral, Tanishq, Ayushi, Diya, Samta, Vidhi, Yash. Everybody is right, including Ayush Verma. Simple answer is yes. In this particular case, we get that it is not violative because it's an exception, that is Partnership Act. Good, Chandrabhan. Let's go to question number 20. 2020 we go. Well, we go to question number 20, we get to see XYZ is a manufacturer of a product like tire, vagera, vagera. Vidhan is employed as a shift supervisor. Contract for 5 years. After 9 months training, started being absent from the job. He resigned without giving a written notice. XYZ had said that such resignation does not hold good. There was a long story given and asked to rejoin, but he has already obtained another employment. XYZ suffered damages due to appellant. They wanted an injunctive relief, उसका मतलब भी बताया हुआ है, to restrain him from employment in any rival company. Decide. For question number 20, we get a simple, serious thought that in this case there was a negative covenant that he cannot join anywhere and which was reasonable. Answer is Bombay. Everyone marked Bombay. I'm happy. We go to the next question. There are 3 people established a firm 5 years ago. And now they are saying, and this firm has a clause that a partner can leaving firm cannot do any kind of business in Madhya Pradesh, did not have any time period for which restrictions will be held. लिखा था specified time, so it is unreasonable. How much time after? After a decade, 10 years के बाद. Decide. It's a simple cakewalk then. He couldn't be stopped at the restriction seems unreasonable. Answer is Delhi. Everyone marking Delhi. I'm happy. We go ahead. We see passage 5. Concept of marital rape. Talking about this concept of marital rape, it's a passage where Indian law has been discussed, and then it was discussed about Sir Matthew Hale, who has this reasoning that it would be presumed that the woman has consented and she doesn't have any bodily autonomy, and said that this happens to be a justification against marital rape. But then he says that in 1992 in UK the landscape of marital rape has changed, and then this is the new view, this is the old view of law which endorsed that marital rape is no rape. Later in 1992 it changed and they said that this is the new view. When we talk about developing countries, only 32 countries which are developing have not adopted marital rape as an offense. Then when we talk about Indian law, that is section 375, and it has an exception, and that exception is sexual intercourse between husband and wife is not amounting to rape, and this is where marital rape is not punishable. And then they say that there is a judgment which has stuck down the exception so far the girl child is below 18 years. Means even if they are husband wife, but wife is less than 18 years, in that case it can amount to marital rape. कारण क्या था इसके पीछे की thought process? That this lady who's less than 18 is incapable of giving consent. उसकी consent is a question, and in that particular case bodily integrity of a girl child had to be protected. Then there's a judgment of Nimesh Bhai where the Indian Supreme Court has ruled in favor of having something called the concept of marital rape. In 2021, the Kerala High Court says that marital rape is a ground for divorce, though not a crime yet. तो मोटा मोटा पैसेज आपको समझ में आया होगा. Let's go to the questions. Vidhi is 15 years, so less than 18 years. Less than 18 years, तो मतलब क्या हो जाएगा? The concept of marital rape will apply. What would be the correct option? The correct option in this case is going to be A, Agra. Vidhan may be charged. Bad reason. Let's go to question number 23. In the facts of the above question, what would be the position if Vidhi was not opposed to Vidhan's advances but revealed them to her friends of her? Vidhi was not opposed. In this particular case, we get to understand that there is no information available in question number 23. No information on this facet. On this facet. So when the question is about 23, answer is going to be D, Delhi. Question number 24. Vidhi has been married to Vidhan for a long time. She has been subjected to marital rape by Vidhan as long as she can remember, after 20 years. Now, there the question is, after 20 years, she reaches to a council, and this entire story is going on, but you ask, what's the question? Choose the correct option about the council's opinion about judicial mindset, and the judicial mindset, as in the view of the council, is that court will not be in favor of giving Vidhi any relief, as the mindset is not to discontinue marital rape. Court ka mindset is not to discontinue, but the reality is the courts have indicated that they want to discontinue. So this opinion about judicial mindset of the council is a wonderful question. This opinion about the judicial mindset of the council, about the judicial mindset of this council, is not correct. Continue होना चाहिए था, should not continue या should discontinue. Not discontinue means otherwise. So talking about question number 24, the council is incorrect. Option is either B or C. This is wrong. ये लास्ट वाला जजमेंट हमने पढ़ा था ना, लास्ट पैराग्राफ, वहां से इन्फरेंस. गुड गोइंग. Many marking D Delhi. Answer C Calcutta. In the facts of the above question, suppose the lawyer advising Vidhi says that the court's outlook towards marriages is to remain clear and leave the sanctity of marriage untouched. And leave the sanctity of marriage untouched. उसमें लिखा था ना केरला हाई कोर्ट saying it's a ground for divorce. असद गलत. The council is incorrect that the court has observed in the past that the notion of implied consent needs to be revisited. There were Kerala High Court, इससे पहले भी बोला गया 2-3 बार in various judgments. नाना भाई वाला judgment as well. निमेश भाई वाला judgment. Good. Question number 26. Which of the following statement is the author of the passage most likely to disagree with? The Western countries have yet to change their laws relating to marital rape. उसमें बोला 33 countries. They say that the Western countries had changed. So author will disagree with it. I'll read further. The concept of marital rape has come into force in present times as a part of discussion. Yes, it's right. He'll agree with this. इसके साथ वो agree करेगा. Sir Matthew Hale was behind the promulgation. The person will agree. Western countries are yet to change their mindset. No. Here is the disagreement. The safe answer of this question is A. Agra. Question number 26. Answer should be A. Agra. दिया हुआ है पैसेज में. Western countries such as UK have already abolished such law, apart from few developing countries. Well, which of the following can be inferred? All of it. 27 is simple, no brainers. It's rather a violence against women? Yes. Personal autonomy? Yes. Yes. Answer is D. Going ahead. Question number, passage number 6. Now, this passage is a passage where a lot of information about character evidence has been given. Alright. Now they say that what is the meaning of character? Here they explain. Character evidence means evidence related to character. It played मतलब past, a pivotal role in civil and criminal law. The conduct and character of a man was used to determine the guilt in the guilt since centuries. However, the evolution of law and judiciary evidentiary value and reliance on character has decreased. The general principle being it's difficult to establish poor character, and further judging by character would mean deviation from the facts to an ambiguous subjective matter. Now, the idea that author is trying to say that while determining guilt of a person, earlier the evidence used to include character evidence, and when character evidence was used कि इसका character कैसा है उसके हिसाब से इसकी guilt decide करो, तो author का मानना है कि guilt तो decide होनी चाहिए facts और circumstances of the case देखकर. फैक्ट्स एविडेंस सर्कमस्टेंसेस ऑफ द केस देखने के बाद डिटरमाइन करना चाहिए पर्सन गिल्टी है या नहीं. यहां केवल उसके कैरेक्टर को देख के करेंगे तो इससे सब्जेक्टिविटी बढ़ेगी और यह सही तरीका नहीं होगा. इसलिए आने वाले टाइम में जिस समय में हम रहते हैं कैरेक्टर एविडेंस को कंसीडर नहीं किया जाता. गोइंग अहेड, उनने कैरेक्टर के बारे में फिर बताया, रेप्यूटेशन एंड डिस्पोजिशन, इन दोनों के मतलब बताए. It is relevant to establish the character of a person relevant to the issue in case. जो केस में इशू है उस केस के इशू में कैरेक्टर की क्या इंपॉर्टेंस है, अगर कुछ है तो वहां कैरेक्टर एविडेंस होना चाहिए. When parties general character itself is an issue, proof must be necessarily to see what general character is. If the general character is not an issue but is used to support other issues, that shall be excluded. अगर उसका जनरल कैरेक्टर ही क्वेश्चन पर है, उसके कैरेक्टर पे ही क्वेश्चन हुआ है, तो ऐसे क्वेश्चन में तो कैरेक्टर पे एविडेंस होनी चाहिए. लेकिन जहां पे इशू कुछ और है वहां पे उसके कैरेक्टर की एविडेंस देख के उस इशू को डिसाइड करना गलत होगा. उस इशू को उसके फैक्ट्स और एविडेंस पे डिसाइड करो, पर कैरेक्टर के एविडेंस पे ऐसे इश्यूज डिसाइड करना इज रॉन्ग. गोइंग फर्दर, evidence to prove good character and to establish the improbability of commission of the crime is also excluded. The court is to judge the matter in front of it, not the character of person. उन्होंने बोला कि एक्सेप्शनल सिचुएशन है जब पर्सन का कैरेक्टर ही क्वेश्चन में हो, उस समय तो कैरेक्टर एविडेंस चाहिए, पर किसी और ऑफेंस को प्रूव करने में पर्सन के कैरेक्टर की रिक्वायरमेंट नहीं है. फैक्ट्स के हिसाब से, एविडेंसेस के हिसाब से मैटर को डिसाइड करना चाहिए. और लास्ट चीज उन्होंने लिखी, नॉट ऑन दी विटनेसेस एज इन देयर एविडेंस कैरेक्टर कैन बी गिवन. मतलब कैरेक्टर एविडेंस अक्यूज का नहीं हो सकता लेकिन विटनेस का हो सकता है. जहां पे कैरेक्टर का डायरेक्ट इंपैक्ट हो ऐसे केस में कैरेक्टर एविडेंस दिया जा सकता है. तो ओवरऑल उन्होंने एक स्टोरी बताई कि कैरेक्टर एविडेंस को कंसीडर नहीं करना चाहिए गिल्ट डिटरमाइन करने के लिए. एक पर्सन ने जो गिल्ट की उसको उसके फैक्ट्स एंड सर्कमस्टेंसेस के हिसाब से देखो. कुछ ऐसे एक्सेप्शनल सिचुएशन है जहां कैरेक्टर एविडेंस को कंसीडर किया जा सकता है. सो दैट इज ऑल द फैक्चुअल मैट्रिक्स ऑफ द पैसेज. Since you've already read it and you understand it, I'm just touching upon the crux of this passage and I'm trying to go with the questions. I'm trying to go faster so that you don't have an iota of doubt. All right. Vidhan has been guilty for the offense of theft several times throughout in his lifetime. He is currently being prosecuted for the offense of stealing bread from the local shopkeeper. Can evidence of his previous character be acceptable? उसने क्या बोला कि अभी चोरी की ना, तो अभी वाले फैक्ट्स एंड सर्कमस्टेंसेस देखो, पहले उसने क्या किया नहीं किया, उसका कैरेक्टर देख के ये वाले ऑफेंस में उसे कैसे गिल्टी आप देख रहे हो, तो इस केस में वो एक्सेप्टेबल नहीं होगा. आंसर इज डी, दिल्ली. नो, रॉन्ग. नो, रॉन्ग. Of course, answer is D, Delhi. Let's come to question number 29. Coming to question number 29, Vedanta is prosecuted for the offense of cheating. During trial, he calls his friend Mr. Asatya to give evidence. हमने लास्ट लाइन पढ़ी ना, लास्ट टू लाइन्स, कि कैरेक्टर एविडेंस किसके लिए पॉसिबल है? विटनेस के लिए. Character evidence of witness is possible, and therefore answer is B. I'm sure many are making mistake here. It was a tricky question. 90% student committing error. Only one child till now had got the answer right, and she happens to be Parul Jain. Rest everybody messed up and missed it. रीजनिंग समझ में आई क्या बेटा? अगर रीजनिंग समझ में नहीं आई तो प्लीज पूछ लीजिए. ये देखो यहां लिखा है. This refers only character of those who are party to the suit, not on witnesses, as their case evidence of the character can be given. बी बॉम्बे. असद कुछ समझ में नहीं आया तो पूछो. चलो, let's go ahead. Vidhut is being prosecuted for causing an accident by negligence. Negligence काय की हो रही है बेटा? In maintenance of car. During trial, evidence माना गया कि drunkard है. Now this evidence about his character and his drinking, will it be relevant or admissible? Answer is no again. उसके कैरेक्टर एविडेंस से क्यों डिसाइड कर रहे हो? आंसर सी कैलकाटा. आंसर इज सी कैलकाटा. As per the information provided in the passage, the facts of the last question, the prosecution wants to give a description of the accused as a habitual lawbreaker. Will such evidence be considered as character evidence? हाँ, अभी उसने एक्सीडेंट किया नहीं किया, अब उसको देखो ना. अगर आप बोलते हो कि वो तो हैबिचुअल ऑफेंडर है, वो हमेशा ही गलत करता है, वो आदतन अपराधी है, तो उसकी आदत देख के थोड़ी ना गिल्ट डिसाइड होगी. आपको तो ये देखना है कि लास्ट केस में क्या वो नेग्लिजेंट था या नहीं था. दैट्स इट. So Sundaram marking C Calcutta is absolutely wrong. When we talk about question number 31, this is character evidence and this would not be allowed. A Agra happens to be answer. Now people saying like Laksh Haritwal, this is a character evidence, but still it will be allowed. This is nonsense. This is nonsense. Absurd. Absurd is the word used for the reasoning adopted by two children, Sundaram and Laksh Haritwal. Now everyone else now, because the answer is told, they'll say A Agra, all's marking Agra, they are good. Let's go to question number 32. Which of the following is true in the context of the passage? Question number 32. Let's see. In question number 32, they're asking which of the following is true. When party's general character is not in question, proof must necessarily be received. No, this is false. Not नहीं होता तो सही होता, ये तो false हो गया. When the person is judged by his character, it means he's not judged on the basis of fact. Yes. Character evidence does not hold same importance as it does in earlier time. Touche. Answer to this question is of course B. Bombay. Bombay goes right. So 32, Aviral Billore is wrong. Abhay, Abhishek, Parul, Mahima and Tanishk, they're absolutely right. Question number 33. XYZ are being prosecuted for a gang rape on one Miss A. During the proceeding, the advocate of XYZ, Mr. Vedan, wants to give an evidence that stating that the women is of loose character. Now this entire story saying that women ka character evidence. The question is, यहाँ पे तो fact in question is whether the rape has been committed or not. ऐसे evidence का इससे कोई लेना. I got a bit irritated. There's one child, Aviral Billore, saying silly mistake. बेटा जीवन में याद रखना, कोई मिस्टेक सिली नहीं होती. क्लैट में हर मिस्टेक की कीमत है टाइम प्लस a loss of -1.25 in score. So no mistake is silly. Coming quickly on the questions, ये वाले फैक्ट का इस क्वेश्चन से कोई वास्ता नहीं था. आंसर इज गोइंग टू बी सी, कैलकाटा. A lady's character has nothing to do while determining guilt under offense of rape. Answer is Calcutta without an iota of doubt. Go further. Vidush is prosecuted for causing an accident by negligence. During the trial, wants to give an evidence of Vidush being inebriated on the night of accident. Can such evidence be admissible? Yes. यहां पे लिखा हुआ है कि कार एक्सीडेंट नेग्लिजेंस से हुआ और फैक्ट्स में एविडेंस हो रही है कि ये ड्रंक था, इनेब्रेटेड था. तो इनेब्रेटेड इज डायरेक्टली रिलेटेड टू नेग्लिजेंस. So going by question number 34, the answer is without an iota of doubt A. Agra. Everybody marking A, they're good. Those who are sleeping at home, so not marking, not participating, praise the Lord. Now this is Vikas Dubey encounter. Then a legal framework, National Human Rights Commission, custodial death. What is the law? That there are 1993 guidelines where custodial death must be intimated within 24 hours to National Human Rights Commission and all the documents thereto. If the death is prima facie found to be a death that has took unlawfully, Commission would grant compensation to victim's kin and penalize the errant officers. ठीक है. कस्टडी में डेथ हुई तो जिन पुलिस वालों की गलती से हुई उनको सजा मिलेगी और जिसके घर का कोई पर्सन कस्टडी में मरा है उनको मिलेगा कॉम्पनसेशन. 1997 the then NHRC chairperson Justice M.N. Venkatachalaya, he has written a letter saying that if state policemen are found guilty or responsible in custodial death, they will have the same defenses available in law as they are available to common man and have no special protection. बोला अगर पुलिस वाले ने कस्टडी में किसी की डेथ अनलॉफुली कॉज कर दी तो जैसे कि एक आम आदमी के अगेंस्ट में मैटर चलता है वैसे ही चलेगा. इन्हें कोई प्रोटेक्शन नहीं दी जाएगी क्योंकि वो पुलिस वाले थे. स्टिल दे विल नॉट बी गिवन एनी प्रोटेक्शन. दैट इज व्हाट जस्टिस M.N. Venkatachalaya's letter to the chief ministers mean. Essentially, this meant that for every case of custodial death, the concerned officer would be on trial. Their actions could not constitute an offense only in the two circumstances. ये दो क्या हो गई? ये दो गई exceptions. Exception क्या है कि आप डेथ कॉज कर सकते हो सेल्फ डिफेंस में. पुलिस वाले को गन पॉइंट पे रख दिया अक्यूज ने या जिसको अरेस्ट कर रहे थे, क्या करेगा? गोली तो कोई चलाएगा. When you're up against the gun, what matters? Who fires first? Who fires first? तो ये एक बात है कि जब उसको अरेस्ट करने जा रहे हैं और उस पर्सन को सेल्फ डिफेंस में पुलिस वाले ने कुछ फायर किया या डेथ कॉज की या अरेस्ट कॉज करने के लिए उतनी फोर्स यूज करनी पड़ रही थी, वो भाग रहा था, इन पे फायरिंग कर रहा था, तो सच काइंड ऑफ फोर्स वाज टू बी यूज्ड. दीज आर दी टू एक्सेप्शंस. FIR ऐसे केस में रजिस्टर होगी सेक्शन 202 which penalizes 302 which penalizes culpable homicide. इंडियन एविडेंस के हिसाब से बर्डन ऑफ प्रूफ डिफेंस पे रहेगा, मतलब कि पुलिस पे रहेगा कि वो प्रूव करे कि उसने ऑफेंस नहीं किया है. The verdict was given in PIL that every custodial death would be probed by a magistrate under section 170 of CRPC. फिर बोला गया है कि कोर्ट ने कई बार बोला इंडिपेंडेंट इन्वेस्टिगेशन होनी चाहिए फॉर एनकाउंटर. द कोर्ट सेड दैट द इन्वेस्टिगेशन शैल बी कंडक्टेड बाय CID और पुलिस टीम ऑफ अनदर स्टेशन अंडर सुपरविजन ऑफ अ सीनियर ऑफिसर एट लीस्ट अबव द लेवल ऑफ द हेड ऑफ द पुलिस पार्टी इंगेज्ड इन एनकाउंटर. मतलब ऐसे केस में कभी भी जब प्रोब हो तो दैट कैन बी डन बाय whom? दैट कैन बी डन बाय अ CID पर्सन और पुलिस टीम. और पुलिस टीम में जिस टीम ने ये ऑफेंस किया था, डेथ कॉज की थी, उसकी पार्टी को जो हेड कर रहे थे उससे सीनियर ऑफिसर इसकी प्रोब करे, इसकी इन्वेस्टिगेशन करे. सो दिस इज द पैसेज एट हैंड एंड लेट्स स्ट्राइट अवे ब्रेक इनटू द क्वेश्चंस. Vidhan was arrested by police on the charges of robbery. He was kept in custody for about 2 months. He was given third-degree torture. He died. What is it? It is custodial death. And when the question is about custodial death, then what would be the answer? Police would be liable. For what? For culpable homicide, not murder, because murder word is not used in passage. Answer is A, Agra. People marking A, great going. Soumya, Vinay, Aviral, Parul, Mahima, Asad, Abhishek, Samta, Priyashi, Ankul, everybody. Good going. Consider the above situation before police resorted to violence. Vidhan attacked a policeman with knife. Police retaliated. Private defense. Vidhan died. Will police be liable? 36 is no. Wrong reasoning in C. Answers D. Delhi. So Soumya, Jayesh, Vinay, Asad, Harsh, Ankul, Paki, Samta, Mahima, Vidhi, Aditi, Alok. Good. 37. Vidhi is under custody. Dangerous terrorist. So policeman shoots her on forehead, leading to instant death. What is it? Custodial death. Not covered in exception. So question number 37. Ankul is right. Vedic is wrong. Asad correct. Priyashi is correct. Vidhi correct. Jayesh, Vinay, Anurag, Mahima, Alok, Sundaram, Tanishq. Everybody is correct. Answer is going to be C, Calcutta. I repeat, C, Calcutta. Question number 38. Vikas was a proclaimed terrorist under UAPA. Proclaimed terrorist under UAPA. He was arrested in Indore by police. He was in transit to Kanpur. On the way, there was an encounter. Now, in this case, Vikas ran away, snatching gun. This entire story. Answer is very simple. Everybody marking A, Agra, and A is correct. The penultimate question of the day. Why according to author encounter was flouted? Wrong. ऐसा कहीं नहीं है. Wrong. Right. Answer is B, Bombay. Question number 39. Investigation उन्हीं के पुलिस ऑफिशियल्स करते ना. Excessive defenses are not available. 39 का आंसर is B, Bombay. 39. The last question for the day. Which of the following is correct inference drawn from the passage? M.N. Venkatachalaya advocated preferential treatment to police? No. It's incorrect. In the case of custodial violence, the burden of proof is on defense. This is also no. Barring exceptional situations like this and this, yes. Answer is C, Calcutta. So C, Calcutta happens to be the answer. That's technically all for today. That's all from my end. Now, this is the message with which I would want to end this day. Have the right approach, right mindset. Trust me, getting more or less marks in these last tests does not matter much. These tests are just to hone your skills, just to make you better, just to make you realize that yes, these are the things that you can find on D-Day. So more than this test, work hard on its analysis, understand more, have more clarity. That's all what is required to make it large. Stay happy, stay energetic, and yes, stay logical with Vidhigya, your best pal in CLAT preps. Forget not, jeetna to hame hi hai. All the best, everybody. Good night. Take care.